Okay, so chapter 14 is about mental health services and legal and ethical issues. So, when it comes to our mental health and the law, we have to be able to manage care for people with serious mental illnesses, which require a balance between several things. We have to look at a patient's rights as an the individual's right to safety, and also society's rights to safety and security. All of these factors may be difficult to determine um, in some cases. So, when we are talking about civil commitment laws, these are going to be the legal declaration of mental illness. It tells us when a person can be placed in a hospital for treatment, and these laws and definitions of mental illness can vary from state to state. So, the general criteria for civil commitment tells us that a person has a mental illness and needs treatment, and if they are a danger to themselves or others, or if they are in what we call gravely disabled. That means they can't take care of themselves, or they're not showering, they're not eating. And all of those are reasons that we can put someone on a 72-hour hold against their will. The police have the power to check on the health, welfare, and safety of society. And then Parents Patry says that the state acts as a surrogate parent for a person who receives care for mental health concerns to prevent them from being a danger to others. So, when it comes to civil commitment, the initial stage is a person first is going to not seek help on their own. Other people around them might feel like they need help, but the person doesn't see it. There might be a petition made by a judge on the behalf of the person who needs care, and that individual is then notified of the commitment process. After that, there are some normal legal proceedings that take place, and then the person is determined whether or not they should be committed. The judge will determine that, and the decision will be informed by different psychologists and psychiatrists, people who have expert opinions. So, when we define mental illness, we need to think about a number of different things. For a legal concept, mental illness is anytime somebody has a number of severe disturbances. It doesn't necessarily mean a psychological disorder. And so the definition of mental illness is also going to vary from state to state. Some mental disorders are often not considered a mental illness by law. For example, somebody who's intellectually disabled and has an IQ below 70, sorry about that, might not be considered having a mental disorder depending on the state they're in. And then also those substance related disorders, they may or may not be considered, depending on the state, as being a mental disorder. So when we think about civil commitments and if somebody is dangerous to themselves or others, we have to be able to assess the role of dangerousness. So there's often a misconception in society that people with mental illness are very dangerous, when that's just not the case. Most people with mental illnesses are not dangerous to society. Many times, ethnic minorities are often seen as being more dangerous, and we have to be careful with trying to label people as such. And then the vast majority of people with mental illnesses are not dangerous. Early Supreme Court rulings put restrictions on involuntary commitment on those 72-hour holds. They told us that a person who was not considered dangerous could not be committed. They also said that if there's a need for treatment alone, that's not enough for a commitment. And if somebody is gravely disabled and just not taking care of their basic needs, that's not sufficient for civil commitment. Because of those findings, There was a criminalization of the mentally ill. There was also an increase in the amount of homeless people. Um, there was a there was a move towards deinstitutionalization, which is when all of the large psychiatric hospitals closed. And when those hospitals closed, most people with mental illnesses, they didn't have families to go back to. They didn't have a home to go back to. So many of them ended up going to the street. And then there was also trans institutionalization, where many mentally ill were sent to community care centers. So eventually, that idea of civil commitment was broadened a little bit. So we started to look at involuntary commitment as being necessary for people who are dangerous and non dangerous and people who are in need of treatment. So NAMI, or the National Alliance on Mental Illness, has been working a lot and arguing for further reforms when it comes to commitment issues. So, when we talk about the nature of criminal commitment, this has to do with someone who is mentally ill who has committed a crime. They're often detained in a mental health facility for evaluation. Um, and the court system only wants to know if they are fit to stand trial. Many of them can be found guilty or are not guilty by reason of insanity. The insanity defense is a legal term, it's not a psychological term. People have who end up having this defense have been accused but found not guilty because of insanity at the time of the crime. Um, they are often sent to treatment facilities rather than a prison. And we've got a few treatment facilities in Texas for that. And many of them are like mental health hospitals that are for those who are criminally insane. And the diagnosis of a disorder is not the same as insanity. And this is also frequently portrayed in the media, but is also very. So, when it comes to definitions of insanity, the M. Naughton rule is the insanity defense that where things kind of originated, which said that people who are insane can't distinguish between right and wrong. The Durham rule involved a more inclusive definition, which said that a crime is the product of a mental illness. And the American Law Institute standard said that insanity has to involve knowledge of right versus wrong, self control, and diminished capacity. So there have been a number of instances where the insanity defense have been used, and some of them created outrage. For example, the John Hinckley case, which found him not guilty by reason of insanity. 75% of states moved to abolish or change their insanity defense after this case. And people started to believe that the insanity defense is a legal loophole and a way for people to get away with committing crimes. But the truth of the matter is that the insanity defense is used in less than 1% of criminal cases. Most people who are found to be criminally insane are going to spend the rest of their life in a mental hospital. And there have been some changes regarding the insanity defense, which tells us that people can be guilty but mentally ill. So that's the GBMI, which allows them to get treatment and punishment. Therapeutic jurisprudence occurs when we use the knowledge we have of behavioral change to help those who are in trouble with the law. This can help with problem solving in courts because it can help us address the unique needs people have with specific problems. It can also help us with delayed sentencing under the conditions that an individual holds a job for 6 months. When we are trying to determine if somebody is competent to stand trial, we have to look at if they can understand the legal charges that are held against them. If they can assist in their own defense, can they actually talk coherently to their lawyer? Those things are going to be essential for the trial and legal process because we cannot, it would be considered unethical if we tried somebody for something that they didn't fully understand. And the burden of proof has to be on the defense. Some of the consequences that have occurred because of the incompetence is the loss of decision-making authority and having involuntary commitments, but without limits. So a duty to warn happens if a client threatens harm to another person. And there was a big case, the Tarasoff versus Regents of the University of California, which involved a situation where somebody was harmed when they were not warned by a therapist that the person had made a threat in therapy against them. And this case let us know that we must warn others if we're a therapist of danger against them. The Thompson versus the County of Alameda said that those threats that are made must be specific in order to warn. So if in doubt, therapists should consult with a colleague. But some states have duty to warn laws while others do not. Texas is actually not a duty to warn state. Instead, what the state of Texas has said is that clinicians have the permission to warn medical or law enforcement authorities of a person's intent to harm another person, but not the other person at risk. So medical professionals, the police can be warned, but not the person that somebody says, I'm going to harm them in Texas. An expert witness in a criminal proceeding, if a psychologist is called as an expert witness, they are supposed to have specialized knowledge and expertise in the area they are witnessing for. They can assist in competency determinations. They can assist in making reliable DSM diagnoses. They can provide advice to the court regarding psychological assessment and diagnoses, and they can assess malingering or faking symptoms. When it comes to patients, they also have rights. Patients can't be involuntarily committed without treatment. The treatments used must reduce their symptoms and provide them with humane care. And they also have the right to the least restrictive environment, which says that their treatment must be within the least confining and limiting setting possible. They also have the right to refuse treatment. And this is often used in cases involving medical or drug treatment. If a person says, no, I don't want to take it, they can't be forced to take it to become competent for trial. When it comes to research participants have a right to be informed about the research. That involves informed consent, not simply consent alone. They also have a right to privacy. They have a right to be treated with respect and dignity. And they have a right to be protected from physical and mental harm. They also have a right to choose to not participate in research. They have a right to becoming anonymous in the study. And they have a right to safeguarding of their records. When it comes to clinical practices, guidelines, and standards, the Agency for Healthcare Research and Quality tells us that there are efficient and cost-effective mental health services, and we have to disseminate the relevant state-of-the-art information to practitioners and the general public whenever they are found or discovered. That we should establish clinical practice guidelines so that we can assess and treat disorders appropriately. The American Psychological Association provides standards for clinical efficacy when it comes to research and clinical utility as well. So if you take a look at this chart, it gives us an overview of how we can construct psychological intervention guidelines. And here's some more parts of that chart. So to summarize, societal's views and laws about mental illnesses have changed over time. Mental illness is a legal term, not a psychological term. And civil commitment is a legal process. When it comes to criminal commitment, we have to have criminal behavior and mental illness, as well as competence, insanity, and criminal culpability. Those all are different terms that can tell us whether or not someone is considered criminally or should be criminally committed. Mental health professionals can play important roles in legal proceedings and sometimes act as expert witnesses. And patients and research subjects have basic rights that have to be honored. I hope that this will help you guys understand the information in chapter 14.